Next matter come before the court is State of Ohio versus Matthew Ventura. Both sides will have 15 minutes to present oral argument. If you're the appellant, you may reserve up to 5 minutes for rebuttal. I'm keeping the time. If you let me know when you get started, that helps me in keeping the clock and letting you know when you are reaching into any rebuttal time that you wish to reserve. Please don't use the names of victims or minors as we are recording this, and it will be posted on the court's YouTube channel. The judges have read your briefs, and we are ready to see what you are. Would you like to reserve any time for rebuttal, counsel?
Yes, Your Honor. I'd like to reserve 3 minutes
Thank
for
you.
rebuttal. Thank you. May it please the court, my name is Brent English. I'm counsel for Matthew Ventura. He is the appellant in this case. Mr. Ventura is a police officer in the city, or not the city of Medina, but in Medina Township. He's been a police officer for 21 years. He lives in Medina, or at least lived at the time in Medina, at a particular location with his wife, and they had what she referred to as an unorthodox relationship, in as much as she would occasionally, and frankly, quite often, tell him to leave, and he would leave the house. He was ultimately charged in this case because he came back to his home to assist with a birthday party for his autistic 10-year-old son. He was charged with falsification and with criminal trespass. He went to a jury trial, and as the court knows, he was found not guilty of falsification, but he was found guilty of the criminal trespass charge. We believe the trial court erred in a number of ways. The first way being that the trial court expressly excluded relevant, competent evidence from the jury's consideration. We filed, prior to the jury trial, a list of exhibits. We filed the exhibits themselves. They are exhibits that showed that Matthew Ventura resided at this house. He got his mail at the house. His driver's license was at this house. That he received bills at this house. That he lived there in every way for the last 11 years. The documents would have gone a long way to showing the jury that Mr. Ventura had at least joint custody of the house and therefore could not be found guilty of criminal trespass. The trial court, however, said that he felt that the documents were, quote, irrelevant, and he specifically directed me, as the trial lawyer, not to refer to them in any way. And any time I even came close to the issue, I was admonished by the trial court that the motion in limine filed by the state had been granted and it would be strictly enforced. In fact, at one point, it was pretty clear that I was going to be held in contempt if I asked another question that would identify Matthew Ventura as living in that house. I believe, respectfully, that that is a fundamental mistake by the trial court, and as a result, the judgment of conviction should be reversed. Furthermore, there was the evidence in this case showed that my client had lived in this house for 11 years. This was his house in every way, except he did not own the house because his still wife owned it home, and she had owned it since 2005. However, both of them jointly lived in this house with their son, and the only thing that was unusual about the case is that she would occasionally get upset. I called it a snit, or it was a very unusual situation. She would get upset and demand that he leave the house, and Matt, because he's a police officer and he didn't want any kind of difficulty at all would leave the house and go and stay in a different place for a period of time while the situation calmed down. It appears that the trial court thought that that constituted him essentially leaving the house and no longer having custody or control of the marital residence. And respectfully, I think that is wrong. At least the jury should have seen all of the evidence that showed that not only lived at the house, but paid all the bills, or at least a lot of the bills at the house, and regarded the house as his home. The case law is pretty clear that although a husband or a wife could be charged with criminal trespass, the case law shows that every time that that's actually occurred is when someone is out of the house for a significant period of time and has no real involvement with a particular residence that is in question. But that's not the facts in this case. The facts in this case are quite opposite, and as a result, because the trial court refused to permit this competent, relevant evidence, we were unable to convince the jury of his innocence. In addition, we determined that we found out after the case that Matthew Ventura's son, who was at the house that day, his name is Josh, had actually informed Mrs. Ventura, I'll just use her name as that way, that he was going to be at the house. And she had testified at trial that she had no idea that the children were going to be there, and she opposed them being there. That would have been a very relevant fact for the jury to consider, so we filed a motion for a new trial.
Counsel, how was that newly discovered, if it could have been discovered at the time of trial?
Well, frankly, it technically could have been discovered, but we did not discover it, even though I specifically inquired of the witness as to contact that he had had with the alleged victim, and he did not recall that he had had such interactions. But then subsequently, he recalled that he had these interactions, and so therefore we filed a motion.
Are you saying that you inquired while he was on the witness stand? That's in the record?
Yes.
Okay, thank you.
And moreover, I inquired privately before he testified.
Right.
But that's a different story. The trial court did not hold a hearing, did not do anything other than deny my motion for a new trial, and I respectfully submit that that was error under the circumstances. So, if the court has no further questions, I'll reserve the remainder of my time for rebuttal. Thank you.
Seeing none, thank you. You'll have your full 5 minutes for rebuttal.
Thank you. I'm sorry I'm moving slowly, but that goes like that.
I'm very sorry to hear that. That sounds painful.
I guarantee you, this is one thing you do not want to happen to you.
Okay. Good morning, Counsel.
Okay.
May you please support, my name is Megan Philbin. I represent the appellate of the state of Ohio in this appeal. This appeal arose, as Mr. English stated, this appeal arose after Mr. Ventura was found guilty at jury trial of the criminal trespass, but not guilty of the falsification charges. So Mr. Ventura and his wife, AV, I'm going to indicate it's AV, in case she's designated as a victim in this case, they had separated on May 4th of 2021, and Mr. Ventura had moved out of the home on that date, and we're talking about the Worcester Lane home in Medina Township. The home in question was originally purchased by AV prior to the marriage with Mr. Ventura, and Mrs. Ventura resided and controlled the residence for the entirety of their marriage. However, there were times that Mr. Ventura was living with her at that residence, and he was getting his mail there, he was getting his pay stubs had that as his listed address. So there were times that they were both living in the home together. I don't think that's disputed. But at some point during their marriage, Mr. Ventura purchased a home separately. And when they would get into these disputes, he would move out of the home, leave the home for some time period, and go to this other residence that he had maintained separately. So after May 4th of 2021, AV had exclusively resided in the residence and controlled the residence. That's the victim in this case. So May 4th was the date that they had separated. The date of the incident itself was May 22nd. So a couple weeks after they had separated, it was coming upon, I believe they have a minor child, it was coming upon his birthday, and they were communicating with each other, AV and Mr. Ventura were communicating about this birthday party for their son, and Mr. Ventura wanted to go to the home to, I believe it was to set up a pool in the backyard, and Mrs. Ventura indicated to him she did not want him to be at the residence. She said, no, do not come to the home. There was some back and forth between the parties, and Mrs. Ventura, AV, indicated that, I will not be at the home, do not go there. And she said something, it's in the record, LOL, I will not be there. So the whole discussion that they had was about Mr. Ventura going to the home, to the outside of the home, to set up this pool and to, I believe, power wash in the backyard. So after this discussion happens, Mr. Ventura decided he was going to go to the home anyways. He arrives at the property, proceeds to do what he had told Mrs. AV, what he was going to do, and he power washes that side. At some point, Mr. Ventura decided that he was actually going to go into the residence and retrieve a motorcycle. This was not something that he had discussed with AV, and I believe in the record there is some discussion out there. This was disputed property. I think that's Mr. Ventura indicates that on the body camera, that this motorcycle was disputed between the two of them. He had never asked Mrs. Ventura if he could go into the home to retrieve the property. And when Mr. Ventura, on the date of this incident, so May 22nd, when he tried to get into the home, he found that it was locked, and it was a lock that he did not have a key to. So he determined that he was going to get a locksmith to get into the home, to gain access to the home, and he contacted the Medina County Sheriff's Department to have an assist to enter into the home. So this locksmith comes out, and upon Mr. Ventura showing him his license, which does indicate that that was the address he had been residing at before, it says that Worcester Lane address. They open up the home, and Mr. Ventura gains access with the sheriff's deputy. The importance of the sheriff's deputy in the state's case is that he had a body camera on, and he was able to film Mr. Ventura's reaction to getting into the home. So he goes inside the home, he obtains the motorcycle, and he laughingly on body camera states to the officer that AV will hate this because this is disputed property. She'll hate that he got the motorcycle, and she's been hanging this over my head.
Counsel?
Yes.
I know you said that they had separated, but do you agree there was evidence presented that this was a common occurrence between the two of them?
Yes, I believe that comes from AV and Mr. Ventura as well, that they had this common separation, and they would be separated sometimes for just days, sometimes it was weeks, and it was a common occurrence in their marriage that they would go into separate homes, and she would exclusively stay in the Worcester address, that being the victim.
Was there any evidence about him coming and going or gaining access to the home during the prior periods of separation?
I do not believe there was anything in the record indicating him going to the residence during the separation periods.
So nobody probably asked, right?
I do not believe so.
Okay, so I guess I'm just thinking about all the cases that we see where people, one person does move out or whatever, and it seems like there's always court orders that pertain to this and control what happens to the marital residence. In other words, a husband or a wife is given exclusive possession. If there's maybe some type of, it could be temporary orders, that happen immediately. Also, there could be,
contact orders, and many times police have to come to a home to actually remove one husband or wife because they have equal possession of the house. How do you reconcile all that with what happened here?
Your Honor, it's the state's position. I do not believe that there needs to be some order specifically that indicates one party has the exclusive control or possession of the residence. I will say that at some point during their marriage, I believe it was the year prior to the incident, there was a protection order that one of the parties, the AV, had obtained. Eventually, I believe it was actually dissolved. They were going through the process of going through a divorce. I don't know where they are at currently, but at this point, all parties had agreed that Mr. Ventura was no longer in the home May 4th. So there was no question amongst AV or Mr. Ventura that that was the date that he moved out. And Miss AV...
When you say moved out, did he take all of his clothes? Did he take all of his belongings?
I do not believe he took everything because obviously there was a disputed item in the motorcycle that he had gone back to the home. But he had taken personal effects, I believe, is what he had testified to the other residents that he had maintained outside of the Worcester address.
Was there evidence as to his clothes still being at that residence, for instance?
I'm unaware, Your Honor. So AV did use a lock that Mr. Ventura did not have access to the key. So he didn't have a key for that one lock that she employed after he had moved out. But she also had employed the use of a bolt type lock in the garage, and she also had changed the passcode to the garage as well, so he could not gain access. So from AV's perspective, she had taken every measure that she could to prevent him from going into the home. Mr. Ventura also had asked to go to the home, which states position that does signify to him that he knew he had to get permission to be there, to have some kind of discussion to make sure she was okay with it. In the record as well, that body camera that I had described, so Mr. Ventura had gained access to the home with this sheriff's deputy. At a certain point, his son, who was present at the time of the incident, indicates to him, I'm sorry, it wasn't his son, it was his daughter, indicates to him, AV just drove by, she knows she's here, something along those lines, and Mr. Ventura's response is, let's get out of here. So state's position that also...
You can finish your thought, I'm sorry. State's position that also...
That signified that he knew he should not have been there, should not have been inside the home, and he was trying to get out of there because he finally knew, like she realized that he was there inside the home.
How relevant is what her current desires were on that particular day, as it's even text message, equivocal or unequivocal text messages notwithstanding? If the law says that both parties have to agree that he no longer resides there, and residence being different than possession, right? How relevant is it that she didn't want him there that day? Let's assume that there's an overwhelming amount of evidence that she did not want him there.
Well,
How relevant is that?
Well, I believe that it's the both parties' understanding of what the relationship is and what they're both committed to do. So in this circumstance, AV's perspective, he wasn't permitted to be there, and Mr. Ventura's understanding that he wasn't necessarily permitted to be there without permission either.
Or that she didn't want him to be there?
Yes. I mean, I think both of their meeting of the minds, I guess, is important in this case. So both of them understanding that she's the one who has the control of the property, and he needs to get permission to actually go into the home. He knew he needed to have this discussion with her. He just did not like the answer that he had received from her.
To Judge Carter's point, however, we often have these cases where marital parties, even parties who don't have a history of separating and reconciling, ask for law enforcement to enter a home. And we don't often see criminal, protection orders notwithstanding, okay? We don't see criminal trespassing cases, so that, you would agree, makes this one a little unique?
I think it is unique that they are married persons. I think I think there is substantial evidence of what the understanding of the relationship and where they were at the time of this incident. I think there was substantial evidence of who had the custody and control of the property, and I think who had permission to actually be there. So it is a interesting case. It is unique. I think it is the discretion of the prosecutors and the police departments if they would enforce criminal trespass in those circumstances. So it was just the discretion of the prosecutors in this case that this one actually was enforced.
So in this case, so the facts are critical.
I would agree, I think, but in every case, the facts are critical. So it's a unique fact pattern, however, it still meets the elements of criminal trespass. I think there's case law that substantiates that. We had cited State versus Lilly, and I believe State versus O'Neill to address this issue because it is a unique fact pattern with it being a married couple and one of the parties having custody and control of the residence.
I just wanted to ask you another question. I didn't want to take up too much of your time. I guess what I'm getting at is, since this is such an unusual situation, and I agree with you with the majority of cases, facts are critical. I don't know that they all are necessarily critical, but the majority of cases. But I guess my question is, wouldn't that be even more reason that the court should allow the evidence in that the defendant wanted to provide about what he really, how involved he was, and, that he paid bills, that he still received his mail there? Wouldn't that go into the understanding of what the parties believed in regard to who resided there?
Well, respectfully, it's the state's position that those exhibits and documents that were provided to us were not specific to custody and control of the residence at the time of this incident. So from May 4th to May 22nd, these documents did not show that Mr. Ventura had custody or control of that residence. What was provided to the state was a copy of his license that was from years prior, that it was issued years prior, so it didn't tell specifically was he actually residing there on this date at this time. And the other documents that were provided were, say, bills that had used this address or bills for this address leading up to this incident. So a lot of these historical items, the state had objected to them coming in as exhibits because I don't think there was any dispute that these parties had resided as husband and wife at his residence leading up to May 4th. And so that was the state's contention with nearly all of these exhibits, where the dates were far outside of the actual date of this incident. If they had been within that date range, there's still the question, does it actually establish that Mr. Ventura resided in the home at that moment, that he had custody and control at that time?
Let me ask you, I know that Mr. English presents a hypothetical, and I'm going to present my own as well. And that is, husband and wife are arguing, husband has to go out of town for business, wife has had it with him being gone so much.
Mhm.
She says, if you leave, don't come back, the whole bit. And he comes back and the locks are changed.
Mhm.
And he takes a brick and breaks a window.
Mhm.
Is that criminal trespass?
Well, I would say that, one, it is largely dependent on the facts of the case, but also the understanding of the parties. Did they understand that this was where they stood? And were they truly separated, and who understood that they had the custody and control of the property? It's the state's position that AV had custody and control, and all the parties understood that she had custody and control of this property. Otherwise, Mr. Ventura, excuse me, would not have asked for permission to go to the property. If he thought that he could just be there, he would have just showed up. So it's the state's position that the parties understood where they stood at that point in their relationship, and it was AV who had the custody control. I really only got to the one
Yeah,
issue.
you're over time. I let
Yes.
you,
It was my
cards
problem.
clear.
I appreciate that. Thank you.
Sorry.
Thank you.
So let me clarify some things. that the prosecutor just mentioned. First of all, on May 4th, the evidence in the record shows that about 2:30 in the morning, Mrs. Ventura sent a text, or she claims that she may have made a phone call to Matthew Ventura, who was working as a police officer at the time, and told him not to come home. He recognized that this is another example of her being deciding that he should not be there, and so he decided he was not going to come home and deal with it at that point, and so he went to his condominium in Fairmont. That's what actually happened. They talked back and forth between May 4th and May 22nd, when the incident is alleged to have occurred. There is no effort to, quote, gain permission or to seek permission in the record at all. Matt Ventura on May 22nd simply sent her an email saying, I'm going to be at the house and I'm going to do certain things. And she said, first of all, don't come, and then said, LOL, I'm not going to be there. They have construed that as some kind of a demand that he not go in the house. There is no evidence at all about them discussing or her saying that he could not go in the house at all. He wanted to make sure that he was not going to be accused of having stolen something from the house or done something untoward in the house. And as a result, he called a police officer who determined that he could certainly enter the house, that he had every right to enter the house. The brick analogy is interesting, but in this case, he used a police officer and a locksmith to enter the house without damaging it in any manner, and all he wanted was to pick up a rifle that he thought could potentially be a safety problem because, frankly, his wife was having a real episode. It was an AK-47, which he didn't want to have in the house, and his own motorcycle, which he had every right to take. So he took those. There is a body cam, which if you look at, will not show that my client did anything untoward whatsoever, but that he came into the house with the police officer, and the police officer testified in the case that nothing happened in the house that was inappropriate under any circumstances. So the issue in this case is whether there was joint control of the house, and all of the evidence shows that there was joint control of the house. My client never gave up any control that he had to the Merrill residence. This is where he lived. This is where he did everything. This is where he operated out of, got his mail, got his everything that he possibly did. And to answer your question, Judge, with respect to whether he moved his stuff out of the house, the answer is no. There's no evidence that he did any such thing. That the only thing he had at his house in Fairmont were some clothes. But all of his personal property, virtually all of his personal property, was in the Merrill residence. It is exactly the opposite of what the prosecutor suggested, that somehow the parties had a meeting of the minds and Matt Ventura moved out of the house. That's absolutely not what the record shows.
Well, he did tell the neighbors he didn't live there anymore.
Yes, he told the neighbor that he was not living there at the time. But that was accurate, because over a 20-day period, or 18-day period it actually is, he had not been there. But to suggest that somehow by telling a neighbor, I'll just give him I'm not living here at the moment, but I'll give a gift to my son, is hardly evidence of that he has lost control of the Merrill residence, in my opinion. Thank you. I ask you to reverse and remand to the trial court. Thank you.
Thank you both for your presentations today. The court will take the matter into advisement. We will issue a written decision which will be mailed to all sides of this case, and it will also be posted on the Ohio Supreme Court website. And thank you again for coming over to Summit County on this snowy day.